Imagine being trapped. You're in a new country, far from anyone you know. Your legal status is tied to the person hurting you. For many immigrants, this is a terrifying reality. In 1994, the Violence Against Women Act, or Vawa, changed everything. It gave survivors a way to seek safety and legal status on their own. Vawa became a lifeline, saving lives and offering hope. But a promise is only as strong as those who keep it. So, Vawa was this incredible shield for some of the most vulnerable people in the country. It was a carefully constructed pathway to safety. But what happens when the people in charge of that pathway decide to put up roadblocks? What happens when the government agency meant to help survivors starts treating them with suspicion instead of compassion? That's exactly what began to happen under the Trump administration. Suddenly, a system designed to protect victims started to feel like another obstacle, another source of fear and uncertainty. The lifeline that had been so reliable for so long started to fray. The shift wasn't announced with a big flashy press conference. It was quieter, more bureaucratic. It happened through a series of subtle but devastating policy changes and a new, more skeptical attitude from immigration officials. The agency in charge, U.S. Citizenship and Immigration Services, USCIS, started demanding more and more evidence, often asking for documents that were impossible for a victim to get. Think about it. If your abuser controls all the household finances and legal papers, how are you supposed to produce joint bank statements or a copy of their birth certificate? The very nature of abuse often means the victim is cut off from these things. This new approach had a chilling effect. Lawyers reported that cases that would have been straightforward approvals just a few years earlier were now being met with intense scrutiny and suspicion. Immigration officers were given more power to deny applications on the spot, without giving the applicant a chance to provide more evidence. It was as if the default setting switched from believe the victim to doubt the victim. The burden of proof became heavier, the path to safety steeper. For survivors who had already been through unimaginable trauma, this new bureaucratic battle was exhausting and often heartbreaking. The numbers tell a stark story. Under the Trump administration, denial rates for Vawa petitions began to climb significantly. These weren't just statistics, they were real people, real families, whose hopes for safety were being crushed. A denied petition meant a survivor could be placed in deportation proceedings, potentially sending them back to the country they fled, and sometimes, right back into the hands of their abuser. The promise of protection was being replaced by a reality of rejection. The very system created to empower survivors was now, in many ways, re-traumatizing them. The Vawa process was designed as a secret escape hatch for survivors to apply for legal status without their abuser knowing. Confidentiality was crucial. Notices were sent to safe addresses, never to the home shared with the abuser. The first step was filing Form 1360, the Vawa self-petition. If approved, the survivor could then apply for a green card, leading to permanent residency and safety. Proving a marriage was entered into in good faith is one of the hardest parts of a Vawa petition. The government wants to be sure marriages aren't just for green cards. But for survivors, abuse often means no joint documents or shared accounts. Officers used to look at the whole picture: photos, letters, affidavits from friends, understanding that abuse can erase the usual evidence. The survivor's own story was often the most important proof. Proving the abuse itself was the other major pillar of a Vawa case. This is, as you can imagine, an incredibly painful and difficult task. Survivors had to document the battery or extreme cruelty they endured. The law intentionally used the broad term extreme cruelty because it recognized that abuse isn't always physical. It can be emotional, psychological, sexual, or financial. It's about patterns of coercive control that destroy a person's autonomy and spirit. So, the evidence required could take many different forms, and historically, USCIS officers were trained to understand this nuance and look beyond just black eyes and broken bones. For physical abuse, the evidence might be more straightforward, though no less traumatic to revisit. This could include police reports, restraining orders, medical records from hospital visits, or photographs of injuries. But what if the survivor never called the police, out of fear of their abuser or fear of being deported? Many don't. So the system allowed for other types of proof: a letter from a domestic violence shelter confirming their stay, or a report from a therapist or social worker who they confided in could serve as crucial evidence. The system was designed to meet survivors where they were, not to punish them for being too scared to call for help. For extreme cruelty, the evidence was often more subtle. It was about showing a pattern of behavior. This could be proven through affidavits from friends, family, or clergy who witnessed the abuser's controlling behavior, how they humiliated their spouse in public, restricted their access to the phone, or forbade them from seeing friends. A survivor's own detailed declaration was vital. It would recount specific incidents of verbal abuse, threats, intimidation, and isolation. This personal testimony was the thread that tied all the other pieces of evidence together, creating a compelling narrative of the abuse they had suffered and survived. The goal, before the administrative changes, was to build a comprehensive case file that, when viewed as a whole, left no doubt about the abuse and the good faith marriage. Lawyers and advocates knew what USCIS was looking for, and they helped survivors assemble their stories and documents. The process was rigorous, as it should be, but it was generally fair. There was an understanding that survivors of trauma are not perfect record keepers. The system had a built-in humanity, allowing for the messy reality of people's lives. It was this foundation of compassionate, context-aware adjudication that made Vawa a true lifeline for thousands. The system was meant to protect survivors, but under the Trump administration, everything changed. New internal memos at USCIS quietly raised the bar for evidence, making it nearly impossible for many survivors to qualify. Officers, now trained to be suspicious, demanded official documents, joint bank accounts, tax returns, property deeds, knowing abusers often block access to these. Survivors were punished for the very circumstances of their abuse. Even personal declarations, once the heart of a case, were dismissed in favor of police reports or court records, evidence many survivors are too afraid to obtain. The message was clear: if you didn't call the police, your abuse might not be real enough. This shift ignored the realities of trauma and made the process a legal minefield. Lawyers scrambled to meet these unwritten demands, telling clients their stories alone weren't enough. Survivors, already stripped of power, now faced a system that doubted their every word. The humanitarian intent of Vawa was lost, replaced by suspicion and impossible standards. For many, the door to safety slammed shut just as they reached for it. The process became a test of paperwork, not truth. The very system meant to help was now another barrier to escape. Requests for evidence, or RFEs, exploded in number and complexity. What was once a simple request for clarification became a multi-page interrogation demanding irrelevant or impossible documents. Survivors were asked for utility bills from years ago or photos with their abuser from every year, ignoring the realities of abuse. The tone shifted from inquiry to accusation, making survivors feel like suspects. RFEs became traps designed to find any inconsistency to justify denial. Responding to these demands took months, draining survivors and their legal teams. Many, overwhelmed by the paperwork and pressure, simply gave up. The process delayed cases, left survivors in limbo, and blocked their path to safety. The RFE was no longer a tool for clarity, it was a weapon of obstruction. For those without legal help, it was often the end of the road. The Notice of Intent to Deny, or NOID, became the next hurdle. Once reserved for clear fraud, NOIDs were now issued for minor inconsistencies or subjective disbelief. Officers seized on small memory lapses as proof of dishonesty, ignoring how trauma affects recall. A 2018 policy meant a denied case could trigger deportation proceedings, raising the stakes to life-altering levels. Survivors faced not just denial, but the threat of being sent back to their abuser. The NOID was no longer a warning, it was a weapon. Every response became a desperate fight to stay safe in the US. The system's promise of protection was twisted into a threat of punishment. Survivors were re-traumatized, forced to defend their truth against suspicion. The process became a high-stakes battle, with everything on the line. The safe harbor had become a storm. For some, the final test was an in-person interview. Instead of a chance to be heard, it became a hostile interrogation. Officers asked rapid-fire questions, probing for inconsistencies, often misunderstanding how trauma fragments memory. Survivors were forced to relive their worst moments, sometimes shamed or blamed for their choices. The interview became a judgment of character, not a search for truth. One officer's skepticism could erase years of struggle. The protections Vawa promised were lost in an adversarial process. For many, this was the final act of bureaucratic cruelty. The system's last word was often no. These aren't just policies, they're people's lives. Take Maria, who fled abuse in El Salvador, only to find herself trapped again in the US. Her husband controlled everything, her documents, her money, her freedom. When she escaped, a shelter and a lawyer helped her apply under Vawa. She had her story, a shelter letter, and a therapist's report. Once enough. But in 2019, she received a 12-page RFE demanding documents her abuser had kept from her. No joint tax returns, no utility bills, no photos, her reality used against her. The officer even questioned why her husband was never arrested, ignoring her fear of calling police. Maria and her lawyer scrambled for months, gathering affidavits and explanations. The process forced her to relive her trauma, all to satisfy a checklist. What should have been a path to safety became a bureaucratic nightmare. Her life hung in the balance, trapped by suspicion and paperwork. Maria's story is not unique. For many, the system meant to protect became just another obstacle. The promise of safety was buried under a mountain of paper. Fatima, a university-educated woman from Pakistan, married a US citizen she met online. He seemed supportive, but after she moved, he became jealous and emotionally abusive, isolating her, mocking her, and threatening deportation. Fatima found support, learned about Vawa, and filed a detailed petition with evidence of his cruelty. But the officer focused on minor inconsistencies, like a date mix-up, and dismissed her trauma because she had phone access. Fatima's case shows how survivors can be doubted for not fitting a narrow idea of abuse. Lien, a Vietnamese immigrant, was married to a respected man who was secretly abusive. Terrified for her children, she finally fled and called the police. Her husband was arrested, and Lien filed for protection under Vawa and a U visa, both legal options for abuse victims. But instead of safety, the system doubted her motives, punishing her for seeking help and using every tool to protect her family. Lien was trapped again by a system meant to protect her. Amina met her US citizen husband in Nigeria. Their wedding was large and joyful, with undeniable evidence of a real marriage. But after moving to the US, abuse began. Despite overwhelming proof, her Vawa case was denied. The officer believed her abuser's baseless letter over her mountain of evidence. Amina's story reveals a system turned upside down, protecting abusers, not survivors. The stories of Maria, Fatima, Lien, and Amina are not just isolated incidents. They're snapshots of a much larger crisis. When a system meant to offer safety becomes a source of fear, the consequences ripple outwards, far beyond the individual. The very lifeline that Vawa was supposed to represent was now seen as a potential trap, leading to deportation. This fear spread quickly, poisoning trust and making it impossible for people to seek help. Abusers used this climate as proof of their threats. See, I told you they wouldn't believe you. The real tragedy? The silent victims too terrified to even ask for help. For those brave enough to apply, the journey often leads to legal limbo, a place of endless waiting and uncertainty. Applications can languish for years, stretching timelines and putting lives on hold. Survivors are trapped in uncertainty, unable to move forward, always fearing denial or deportation. This instability makes it hard to find housing, work, or even feel safe. Legal limbo steals time, peace of mind, and the chance to truly start over. The most heartbreaking consequence of this broken system is its impact on children. Most Vawa applicants are mothers, trying to protect their kids from abuse. These children, many US citizens, are silent victims, caught in the crossfire of trauma and a hostile immigration process. The system doesn't just fail mothers, it fails American children, tearing families apart and punishing the innocent. These children did nothing wrong. They are citizens of this country. The Violence Against Women Act was a promise, a lifeline for immigrant survivors of domestic violence. But recent policy changes turned protection into punishment, leaving survivors trapped in fear and legal limbo. The system meant to help became another source of trauma, breaking trust and hope. Now the task is clear. We must repair what's been broken and restore safety and dignity for those who need it most. Where do we go from here? The system must return to compassion. We need to reverse harmful policies, invest in training, and clear the backlog so survivors aren't left waiting. This isn't just a problem for lawyers and politicians, it's for all of us. The promise of Vawa reflects our nation's character. Let's keep that promise, together.